Hi, hello everyone. Well, what I would like to talk about today with regards to our building contract law is that the complaints or reports that are being received or that are received by the police and how these reports are usually tackled. Okay, for a start, what I would like to say is most of the contractors or constructions these days they cannot satisfy all customers, and this is because each and every one of us have our own taste. So when it comes to renovation or remodeling of our houses, we all have our own plans of how we want to have it. And whenever we receive the keys to our new house, eventually we will have to look for someone who is actually doing this kind of renovation or building construction works. So from what we can see these days is that there are so many of them out there who claim to be a building contractor, and the unfortunate thing is many of them do not even have the qualification, paper qualification, or even they don't even have any certification from the authorities, and they just claim that they are building contractors, and eventually they are being hired by buyers of new houses or even older houses which need to be remodeled. So first of all, what I would like to say is that we receive a lot of complaints or reports about these type of contractors, mostly those who do not have any legal documentation. That means there was no contract, a proper contract drawn up, or they did not even follow any procedures of building contract laws, which is you need to have a plan, you need to submit the plan, and then you need to get approval from the authorities, you need to get an architect, you need to get an engineer to certify, and you need to go through the process from the start until the end. So most of them, they assume, most of the buyers, they assume that their job is just a very simple job. Probably cost them 20 or 30,000 ringgit. It's not like a $1 million construction project, so they don't need to engage somebody who has all the credentials. But apparently what happens is more than 70 to 80% of buyers end up not satisfied with the job done by these contractors. And from what I can see, the reasons for this kind of problems is there are a few reasons, which is first of all, pricing. When you engage this type of contractors who really do not have a proper construction firm, or they do not even have qualified personnel working with them, apparently the price of their construction work is going to be much cheaper, maybe even 1/3. If you're doing a job for like say 30,000 ringgit, probably if you give it to a more reputable contractor, probably it will cost about 60 or even 80,000 ringgit. So many people, they look at it as price factor happens to be the most important thing that they consider when they first engage the contractor. So everybody, I mean most of us, we know when you want things cheap, you don't get good quality. It hardly goes that way. And the second thing is lack of understanding or communication as well. Because when you call somebody and you don't draw up any documentation, you just tell them verbally what you want, like, you know, I want this, I want that. And that guy's going to say like, yes, I know. He behaves like he understands what you mean, but apparently maybe he does not even understand. So what he does is not what you actually want. Then we also have, like I told you earlier, no proper documentation, no contract, no building plan. And also the skill of the workers that they use is not up to the mark. So apparently the quality of the job is also not up to the mark, or not up to the satisfaction of the customer. And what happens? So the customer is not happy, he goes to the police station, he lodges a police report, he expects the police to flex some muscle or even strong arm the contractor and try to get things done according to what they want. But that's not how our system works, because the police cannot be used as a tool for them to achieve what they want. We only investigate cases that are criminal in nature. Any case that is in the grey area or probably even more towards civil, we will not investigate. So what we will do is we will issue them the relevant documents for them to bring these documents to the court and file a civil suit. Okay, there's also another option which they can try, which is the Consumers Tribunal, where if you have any claims which is below 50,000 ringgit, you can actually try filing it at the Consumers Tribunal, because it will be much more convenient, inexpensive and speedy. So that's all I can say for now. Of course, there are cases where it has gone into much more serious situations where they end up having a big argument. They have a quarrel between them, both of them, and even ends up in fist fights or even somebody getting hurt. So if this kind of incidents happen, yes, we will take action, because that is criminal in nature. But if it's anything related to just construction, then I believe it will be most likely a civil case, unless the contractor had taken the money and not done the job. Maybe he disappeared, then yes, we can classify it as fraud and we can investigate. But bottom line is, when you want to do a construction project, make sure you get the right person, if possible somebody with credentials, then you'll end up having a good project. Thank you very much.
Assalamualaikum warahmatullahi wabarakatuh. I am Muhammad Ibn Hakim bin Maisuf, and today I will be presenting on the cases of consumer and home contractor decided in Consumer Claims Tribunal. For the first case, in 22nd February 2013 in Kota Kinabalu, the Consumer Claims Tribunal here yesterday a contractor to refund 12,000 ringgit in down payment to a house owner for failing to complete the renovation work on the house. The claimant, Kasmir Singh, said he signed an agreement with the contractor, Molinas Mojinmon, on December 17th last year to carry out renovation work on his house, which cost 21,000 ringgit. I paid 8,400 as deposit to Molinas so that he could buy the materials needed for the renovation work. A week later, he called me to say that his father had passed away and asked for another 2,600 ringgit. The total amount paid was 11,000 ringgit. On December 8th, I went to Kuala Lumpur with my family for the Christmas holiday, and Molinas promised me to complete at least 50% of the renovation work by the time I came back from holiday. However, when I returned home, he had not done anything. In fact, I had banked in another 1,000 ringgit to him when I was in Kuala Lumpur, said Kasmir, who sought the refund of the 12,000 ringgit he had paid to the contractor. Molinas, who was present at the hearing yesterday, replied agreed to the contents of Kasmir's statement and was accordingly ordered to pay 12,000 ringgit within 14 days by Tribunal President Dato' Dr. Lawrence SHTN. For the next case, on 5th March 2019 in Johor Bahru, a bank manager was awarded the maximum amount of 25,000 ringgit by the Consumer Claims Tribunal when the respondent to her claim failed to turn up. Kim Leong, 35 years old, was granted 25,000 ringgit out of the 47,504 ringgit compensation she sought from the contractor she hired to renovate her new house in Masai. She lodged the claim when the contractor went missing after she had paid more than 19% of the renovation costs. I started engaging with the contractor in June last year and made the first payment on the same month. A total of 74,172 ringgit was paid in the span of 6 months since he started working for me, as he consistently asked for money to buy materials, she said when met at the tribunal's ruling. Leong added that since January this year, the contractor had stopped coming to the house and was nowhere to be found. I later found out that he had also stolen the original window frame of my house, as well as the access card and keys to the house, she alleged. She added that the work completed on her house was valued at only 26,667 ringgit. The tribunal president, Rashida Abu Bakar, ordered the contractor to return 25,000 ringgit to Leong within 14 days, failing which it could be a criminal offence. She added that, although the total loss was higher, the tribunal's jurisdiction was limited to 25,000 ringgit only and below. Moving on to the next case. In 26 June 2019 in Johor Bahru, moving into a new house is everyone's dream, but the dream could turn into a nightmare for some people. Sales Executive Azlaili Abdul Aziz said she had paid about 80,000 ringgit to a contractor to renovate her 800,000 cluster house in Taman Kota Masai near Pasir Gudang. The money spent on renovations is not worth it, she said when met at the Johor Bahru Consumer Claims Tribunal in Menara Ansor. Azlaili said the work started on March 3rd and was completed on August 31st last year, with her family moving in a month later. We noticed the defects and shoddy workmanship only after moving in, she said. Azlaili said there were uneven surfaces on the walls, tilted window frames, and bad electricity wiring job. When confronted, the contractor claimed there was nothing wrong with the workmanship. She said, adding that only 2 workers carried out renovation works. Azlaili is claiming 17,000 ringgit from the contractor from the total renovations cost, and Consumer Claims Tribunal President Khairul Azrim ordered the contractor to pay the claimant the sum within 30 days. That's all from me. Thank you.
Assalamualaikum warahmatullahi ta'ala wabarakatuh. So today I'm going to talk about how to avoid cheating contractors in Malaysia. So if someone wants to renovate the house, they will find a construction company. But however, there are a lot of issues arise where this construction company run away with the money. That's a problem. So how to resolve this issue? So a lot of avenue or a lot of things that they can do. They can make a police report, they can hire a lawyer and so forth. However, the most effective way that I can share in regards to consumer things is they can lodge a complaint to National Consumer Complaint Center, NCCC. National Consumer Complaint Center is a platform that records complaint from consumer, gives advice on what needs to be done, and act as a mediator between all these parties. So basically, they become a mediator to mediate the thing and to solve the issues, without going to any, court and so forth. And the next thing is that the next avenue, the place that you can go is Tuntutan Tribunal Pengguna Malaysia, TTPM. TTPM is an entity under the Ministry of Domestic Trade and Consumer Affairs, and this is an independent body. They act as an alternative forum for consumer to file a claim in a simple and speedy manner. However, TTPM only have jurisdiction to hear things or to resolve things which are under 25,000. So if your construction things is above 25,000, you can't go to TTPM. However, you can go there for any consultation and so forth. And should I sue the contractor? As I said before, litigation costs a lot of money, and you all know that. And I don't think so. Except if you think that it's relevant for you to go for litigation, if the breach is a lot of money. So I think it's better for you to go for litigation. Should I bash the company online? No, I don't think so, because it will get yourself more in a risky position where this construction company may sue you for defamation and so forth. So it will be very difficult for you to go for bashing online. It will not just solve your problem. Sometimes the power of viral is good, but it's not that good for you to solve your problem. And after that, what you can do is that how to protect yourself from getting cheated by this construction company. So it should start from us, what we should do, what the precaution that we have. So first, never rush into the project, because once people bought the first house, they will start with a project renovation and so forth, and they will start hire a construction company and then do the work, get the job done. But however, this is very risky. You have to do a survey. You have to know the performance of the company and so forth. This is very important. Secondly, do not leave important details out of the scope of the work. As I said, everything you put into writing, from the small things in your house, from the a shower head that you want to renovate, until the discussing the penalty for late job payment, late job completion. You have to put everything in writing. That's very important things. It will save you later. Thirdly, what you can do, never pay upfront in full. Meaning to say, never pay deposit in a very huge manner, in a very huge sum, sorry. So you have to make it like 20% after the job completion, so that the construction company will eventually finish the construction. That's very important thing to do. Fourth, never trust an unbelievably low first estimate, because when you enter into with a construction company, they will come to your house and they will roughly say, "Oh, this will cost 20,000. This will cost 30,000. So you just pay me now 20,000." However, don't believe this is a rough quotation. Ask the construction company to give a full detail uh, amount of money they need to do for the construction. They cannot simply quote how much, because at the end of the day, it will be like triple like the exact amount of quotation that they said earlier. So it will be very difficult. Ask straight away how much it will cost. Lastly, get recommendations, because there are a lot of places where you get recommended, you can get good recommendation about construction company. Under CIDB, there are a list of registered contractors which are registered and qualified, trusted. So you can go there and survey on which of what contractor that you want to hire, and about your capacity, your budget that you have. So I think that's all from me in regards to the how to avoid cheating contractor in Malaysia. Is very vital, it's very important for you to consider, because later on when you buy a house, it is a very key principle that you want to renovate your house. Make sure all these steps you follow. So thank you very much. Assalamualaikum warahmatullahi taala wabarakatuh.
Assalamualaikum warahmatullahi wabarakatuh. Bismillahirrahmanirrahim. My name is Shazil Khairi bin Haji Mustafa. My matric number 1739455. This is a subject record for subject building contracts. And then I want to present about discuss consumer protection on construction in Malaysia. Firstly, the main parties involved in construction in Malaysia is employers, contractors, and architect and financiers. A main building contractor is engaged the employer to carry out and complete the works. This contractor will usually in turn engage the subcontractor to carry out and complete the works. Contractor may also responsibility for the design and all part of the works to execute depending procurement method and contract use. There are four institution and organization involved in this construction. That is Institution of Engineer (IEM), Pertubuhan Arkitek Malaysia (PAM), Construction Industry Development Board (CIDB), and Pertubuhan and Jabatan Kerja Raya (JKR). There is extensive legislation protection consumer from unfair and ill-considered contract, but these rules and many provision of the Unfair Contracts Act 1977 only apply to consumer, not to companies. Or even person acting the course of their business. The general rule of the caveat emptor will normally apply to commercial, not have to any power or obligation to correct contracts which are on site. Like all rules, however, there are exceptions. A court will from time to time to intervene of it consider that its term contract is so onerous that present should have been drawn to the attention the one party to contracts at the time the contract was entered into. This is only applied in exceptional circumstances where one the parties is using its own the standard condition. The law which respects to the required independent of the contract administrator in his role as certifier, and so consequence not independent and partially of the certifier is generally well understood. It need to be appreciated that its duty and role played by contract administrator which matters, not on the who employs his, certainly not in his role where is empowered to exercise his discretion. These are to protect the consumers in construction field in Malaysia. Okay, the potential problem lies when the contractor administrator, when he is playing or entrust which the role of the certifier will lack impartially. This is type of complaint mainly from contractor whose complaint are not infrequently or which justification if the complaint of justified or proof either in litigation more frequently of for construction contract arbitration certifies are void. However, in this issue is much victim of such partially. Frequently the contractor, sometimes the employer, wait for arbitration award of court judgment to see wrong the corrected. The consumer in construction field are protected particularly under Contract Act 1950. According to the Section 71, its obligation of person enjoying benefit non-gratuitous acts. When a person lawfully does anything from another person or deliver anything to him, not intending to do so graciously, and such other person enjoy benefit thereof, the latter bound to make compensation, the former is respect or to restore. The things so done delivered, it is illustrated, a tradesman leave good B house by mistake. B treats the good and his own, he is bound to pay A for them. Second illustration in the act is A save B property from fire. A is not entitled to compensation from B if the circumstances show that intent to act gratuitously. Next, the cardinal change doctrine is response to an owner's ability to make significant change to construction project scope of the works. This doctrine gives contractor the right to work away from contract if they feel that owner attempting to enact cardinal change to scope of the project. If proven, contractor would not be breach of the contract and can file a claim for damages. It is the responsibility of the contractor to prove that a cardinal change was required, which can be raised because if they are unsuccessful, they may be in breach contract themselves. In this case, Ramshells against Freedom NY, it stated the cardinal change occurs when one party effects on alteration would drastic that effectively requires the contractor to perform duties materially different from those original bargain. For instance, the consumers must be served accordingly to the contract. The offended party should be compensated. In the case Dunlop pneumatic tire against New Garage and Motor, it was stated the case is that instance a penalty payment of the stipulate of terrorism of the offending party. The essence of liquidated damage is a genuine, convenient pre-estimate of damage. If the sum extravagant and unconscionable in amount is comparison which the greatest law of the conceivably be proved to have followed the breach, it is regarded as penalty enforceable. In Jin Cham Limited against Barnet Football, the stipulated liquidated damage are held to be penalty. The employee will be able to recover only the amount and liquidated damage he can prove. Jin Cham undertook to supply football kits to Barnet. If Barnet paid late, they were required under terms of the contract to pay interest at a rate of 5% per week. Jin Cham were obliged to pay 20 per garment for each day delay delivery. According to the Contract Act 1950, the concept of inequality bargain is nevertheless a recognized principle of English common law, which is highly persuasive in Malaysia, although it seems highly unlikely that construction contract entered into between two commercial organizations can be declared void on this ground alone. In the pricing economic environment, that there is non-party, not infrequently the employer, who is in a position to dictate the term of contract. The problem for standard construction contract is that it's assumed that the two parties on both sides of the contracting fence are of equal bargain position. The protection parties involved also regarding to the consensus approach. It is an underlying assumption the contract produced and promoted by a professional institution must necessarily be equitable and provides a balanced allocation of risk, and that the legitimate interests of the various parties in the construction industries are well protected. There was wide consultation of various players in the construction industries. The drafting of the CIDB form, even though CIDB is not professional institution, this is certainly drafting. This is certainly the case which all standards form of contract in Malaysia can claim. With the possible exception of PWD 203 forms, we are varying degrees of justification. Next, non-consideration tendering exercise. The standard form as draft do not take into consideration of the implication. Tendering exercise and legal implication on the legally enforceable to the condition they are in provide. One good example is equivalent of clause 12 of Felix from civil engineering. Works are provide that the contractor is deemed to have inspected the site ascent, the condition of the subsoil and many more. The problem which this is, the tender is only given a very short time to complete and submit the tender for project which are large in area extends in length. Okay, it was held in the case Interphoto Picture Library against Stiletto Visual Program that the party seeking enforce the particular onerous condition in the contracts has to demonstrate that the other party was sufficiently aware of the condition in question. In this could not be demonstrated that the condition would not be incorporated into the contract. The defendant in this case failed to return transparency to plaintiff agency and incurred a charge £5 per day plus VAT per transparency. The total sum in contention was £3,785. It was held by the court that when the contract was entered into, the plaintiff should be specifically drawn the defendant's attention to charge for the late return of the negative. Because of this failure, the court reduced the charge from £5 per day per transparency to more reasonable charge of £3.50 per transparency per week. The consumer protection legislation does not normally apply to commercial contract. However, where contractual terms are contained in part 1 standard term and considered by the court onerous, they must brought the other party's intention at the time the contract entered into, otherwise they may be unenforceable. In this case, Workshop Tar Macadam against Hanabi in 1995 condition on the reserve side the quotation referred to all being subject or remeasurement. The condition were not standard from condition and the face of the quotation. It appeared to offer the work of lump sum. The judge held that such of clause was unenforceable as it was not specifically drawn to the purchaser's attention. The consumer of construction should be alert regarding their rights, particularly term that has been stipulated in the contract. It always and abandoned as usually the construction matters involve which monetary time and other parties. That's all.